Aaron.
Yeah.
Why didn't you say it the first time I said Aaron?
Because it's pronounced Aaron?
You done messed up, Aaron!
Aaron is here, everyone. Welcome back for more SPTV, where every day is a great day not to be in a cult. I've been meaning to do this video for a while. Every single day that I open up my browser and my Yahoo News and my Google News, top headlines every single day. Blake Lively, Justin, I still don't know how to pronounce this last name. Baldoni, nobody will ever know. But the reason I've been wanting to do a video about this is because ever since news of Blake Lively's lawsuit broke, the first biggest reaction from lawyers was, how in the hell did she get these text messages pre-litigation? And it turns out there's two things that Blake Lively did in her lawsuit that is very likely going to help future litigation against Scientology. Strategies that have absolutely never been used in Scientology litigation in the state of California specifically. One of them is pre-trial, pre-litigation discovery. And the other one is going through California's Civil Rights Department. Both of these things Blake Lively did. So I've got a bunch of things to share with you here. Let's start out by taking a look at this headline. How did Blake Lively's lawyers obtain bombshell texts from Justin Baldoni's PR team? Okay, we are not going to read this whole article, but there's a few key paragraphs that I'm going to pull out. One element of the story that has fascinated legal observers is how Blake Lively's attorneys obtained Jennifer Abel's text messages in which she and other members of Baldoni's PR team talk about how to bury Blake Lively. Those messages typically would never see the light of day, or if they did, it would only be after years of litigation and discovery. Her lawyers stated in the filing that Miss Lively obtained the communications set forth in this complaint through legal process, including a civil subpoena, but did not identify the source. And then the lawyers basically explained the source of the text messages. And I suspect that the way they were able to get these text messages from the source was that it was a cooperative thing, that the source basically said, well, I'll tell you what, if you give me a subpoena, I'll give you the text messages. But the other paragraph that I wanted to show you here is, it says California law does allow for pre-litigation discovery in certain circumstances. The reason for that is there are some occasions where if you don't have some basic factual evidence, you may not know whether or not you're going to file. You may need that information to make the decision. Okay, and there's one other paragraph I want to share with you from this article. Here we go. Blake Lively's team filed the complaint with the California Civil Rights Department. The state agency can either launch its own investigation or issue a right to sue letter that allows plaintiffs to file a suit in civil court. Complaints to the agency typically are not made public unless the complainant chooses to do so. There's a very important aspect to filing your complaint with the California Civil Rights Department. And one of the most important aspects is whether it allows you to bypass any arbitration agreements that you have signed. And this could actually be a very big deal. Okay, I want to share some things from you, share some things with you from Grok. Okay, the first question I asked was, how was Blake Lively able to get the text messages using pre-litigation discovery? And hold on, I'm just getting the screen share set up. Okay, now this one here is a little redundant because we just covered it in the article, but I just wanted to share it with you. Legal precedent, California law allows for pre-litigation discovery when there's a need to ascertain basic factual evidence to decide whether to proceed with a lawsuit. The process involves proving to a court that there is potential legal action and that the information sought is necessary to assess the viability of that action. Discovery before a lawsuit. The texts were part of Blake Lively's civil rights complaint filed with the California Civil Rights Department, which might serve as a precursor to a lawsuit. This step allowed her team to access evidence that would typically only be available through traditional discovery processes after a lawsuit has been filed. Okay, the next thing that I wanted to share with you is just this blurb about the California Civil Rights Department. The California Civil Rights Department, CRD, is a state agency in California responsible for enforcing civil rights laws. Here are some key points about the CRD. The CRD aims to protect individuals from discrimination and harassment in employment, housing, public accommodations, and state-funded programs. Okay, so specifically, I want to I want to specifically highlight the part where it says employment. I feel like what we're talking about here as it relates to Scientology litigation may be most applicable to cases where Sea Org members, former Sea Org members, are filing lawsuits for things that happened and for the time in which they were in the Sea organization. It, of course, could apply to staff members as well, but there's a specific focus here on employment. Okay, jurisdiction. It handles cases under various laws, including the California Fair Employment and Housing Act, the UNRRA Civil Rights Act, and others related to civil rights protections. It investigates civil rights complaints, provides mediation services for dispute resolution, educates the public and businesses about civil rights laws, prosecutes cases of discrimination and harassment. When you file a complaint with California Civil Rights Division, they will in some cases prosecute the cases themselves. This is going to become important in a minute here. Okay, type of discrimination covered. And yes, let's see. I hate the user interface here. Employment discrimination based on race, color, national origin, ancestry, religion, sex, sexual orientation, gender identity, age, disability, genetic information, marital status, or military veteran status. Housing discrimination. Okay. Filing complaints. Individuals who believe they've been discriminated against can file a complaint with the CRD. The process involves submitting a complaint, an investigation by CRD staff, possible mediation, or if unresolved, moving to a formal hearing or a lawsuit. Okay, so the next step here. Yeah. So check this out. First, I asked the question here, if the Civil Rights Division decides to prosecute a case, would any arbitration agreements the party filing the complaint signed prevent litigation from moving forward? Right off the bat, it does acknowledge that arbitration agreements can prevent litigation from moving forward. Okay. I just wanted to share with you that that is the information that was there. However, look at this from August 8th, 2022. Appellate court rules California Civil Rights Department not bound by private arbitration agreements. And when, and when I ask Grok to summarize this entire thing for me, it says the following. Zoom in a little bit here. The California Court of Appeals ruled that the CRD is not bound by private arbitration agreements between employees and employers when filing lawsuits under the Fair Employment and Housing Act. This decision was in response to a case involving Cisco Systems, Inc., where CRD sued for caste-based discrimination, harassment, and retaliation. This also has to do with anonymity. And God, I hate this user interface. I keep having to scroll up and scroll down. Okay, let's take a look at this. Litigation anonymity. In a related ruling, the appellate court clarified that the trial court must consider potential harm to family members, even those outside California, when deciding whether to allow a party to litigate anonymously. This ruling was made in the context of protecting the identity of a Dalit engineer who feared for his and his family's safety. You guys might have noticed that when someone is trying to sue Scientology under Jane Doe or John Doe, Scientology makes all sorts of arguments for why persons suing Scientology should not be allowed to remain anonymous. And as you can see here, there are specific rulings that have been made about protecting someone's anonymity, specifically when they are going through the California Civil Rights Department. Now, there's one other important thing that I want to share with you guys, and this is about a look-back window in California that is open until the end of 2026 regarding cases where a sexual assault occurred in the workplace and the employer helped cover it up. I cannot imagine a better description for what happens in Scientology when sexual assault occurs, whether it's in the C organization or on staff. And the fact that this look back window exists right now, I mean, for the next 2 years, and combined with the strategy of filing a complaint with California's Civil Rights Department, because normally a sexual assault lawsuit like this would still be tied up with Scientology's arbitration agreements. So we have a look back window. We have a possible avenue of litigation that can basically throw arbitration agreements out the window. This could be very interesting for potential Scientology cases. So let me read this to you. I guess I got to share the right one. Here we go. Window to sue your employer in California based on employers covering up sexual assault until 2026. Here's the information. Let me zoom in a little bit more. In California, if you're looking to sue your employer based on allegations of covering up sexual assault, you have a specific legal window under the Sexual Abuse and Cover-Up Accountability Act. This legislation provides a revival window for claims that would otherwise be barred due to the statute of limitations. Here are the key points. From January 1st, 2023 through December 31st, 2026, survivors of sexual assault can revive claims that were previously barred by the statute of limitations, provided the assault occurred on or after January 1st, 2009. Okay, so that's about 16 years. This allows individuals to seek justice for sexual assault and related claims like sexual harassment or wrongful termination. Wow. To qualify under this act for a cover-up claim, you must allege that you were sexually assaulted. One or more entities are legally responsible for damages due to negligence or other legal theories, and these entities engaged in a cover-up. This act does not revive claims that have been litigated to finality before January 1st, 2020, or those compromised by a written settlement agreement before the same date. This is kind of a big deal. Off the top of my head, I can think of a few cases of sexual assault that occurred in the state of California involving Sea Org members that would have occurred 2009 or more recently. This could be a really huge deal. And that's why I wanted to get this video done. I've been meaning to do it for weeks. I've been dragging my feet on the preparation. And I will probably do more videos on this subject as I get greater clarity on what exactly this means and whether there might be law firms ready to represent people who come forward with claims about this. All right, got a few starred comments here, and then we will wrap it up. Mother of Aiden, hey, Aaron, finally caught alive. Love watching your videos. Keep up the good work. Thank you very much, Mother of Aiden. SC Girl 1969, lawsuit was filed in New York City, right? You must be talking about the Blake Lively lawsuit. I think Justin might have countersued Blake. My understanding is that Blake's lawsuit was filed in California. Otherwise, why go to the California Civil Rights Department? But I cannot claim that I've been following it closely enough to be able to say for sure. And if Blake filed her lawsuit in California, could Justin have filed his lawsuit in New York City? It doesn't seem to me like that would make sense, but what do I know, guys? Lisa Kelson, I hope and pray that people are brave enough to come forward and get the justice they deserve. Mage River, is that Scientology on a platter? Karen McCourt, sexual assault is different from sexual harassment, right? I mean, I think it is different. Northern Girl, but won't Scientology just claim they're not employers? They're a church. They can make that claim. Sure, they can make that claim. But the truth is, you do have a contract of employment. And that's going to be for the lawyers to work out. God, that would be so interesting. That would be so interesting to understand. I'm going to do a little bit more research into some of the decisions that have already been made about whether Sea Org members are employees or purely strictly religious volunteers. Because, staff members have contracts they sign that are 2.5-year contracts or 5-year contracts. And the Sea Org members have their contract that's a billion-year contract. But for legal reasons, Sea Org members are now required to sign those staff contracts every 2.5 or 5 years because signing a contract for the next billion years doesn't mean anything. And just the idea that you would have a legal contract, but that you're a volunteer. I don't know, guys. To be continued on that one. Yes, Scientology would obviously make that claim. I don't know if that specific claim is something that is already proven would hold up in court. So I guess we'll see. All right, guys, just a short and sweet one. Last one for me tonight. Thank you for hanging out with me. Thank you, as always, to everyone who watches until the very end, and I'll see you tomorrow.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.